Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer Podcast. I am Thomas Vick, joined as always by Seth Wilson of Adler Attorneys in Noblesville, Indiana, and we're here to talk about another estate planning topic. Seth, how are you doing today?
Thomas, I'm doing great on this. Wow, we're almost through April,
April's
and
over.
it's crazy. It's crazy. It's always good to catch up with you too. It's been a couple weeks since we've been able to get recording, so it's always fun to catch up and see how things are. And excited to dig into a couple of topics today. The first one on your newsletter that went out kind of jumped to my attention, just given some recent client questions I've had, are this: do single parents need estate planning? And so how do you experience that in your office, and what advice do you often give to clients in that scenario?
There are particular documents that they need to have. When you're you've got a minor child in your care, it's highly advisable that the single parent have a named guardian in a last will and testament, so that if the single parent passes away, there's somebody that a court can say, if there is another parent in the picture, maybe a shared custody relationship, then, it's kind of obvious that the child would just go to the other parent. But there are situations where parental rights may have been terminated, or maybe even that the other parent has predeceased. And so it's, that's one of the things that we talk about here at my law office, is to get a guardian named in a last will and testament.
And I think that's a really important point in terms of, especially a situation where there may be another parent involved, where that intersection of what do I do as I'm planning as an individual to don't know what the situation will be like at the time. The custody situation may have changed. You mentioned that predeceased situation. So there's lots of variables there. And the best thing you can do to help plan and have that peace of mind that in the event that something happens to me in the guardian case, I know my really important thing to work through, think through, and make sure that there's somebody suitable for that. And then your article also mentioned some of the healthcare directive documentation, and I think that's always a good thing to be out. And then we'll kind of want to get into the idea of a testamentary trust, and what your thoughts were on that.
The will is probated, and then the trust is able to be funded by some sort of, it kind of depends on what the particular asset is, but the typical thing is a life insurance policy. And that's a common estate planning piece, is to have a life insurance policy fund a testamentary trust. I actually talk to clients about having a beneficiary as the trust that you've already established, and I think it provides more peace of mind, because that this thing is already established, it's working for you, and the life insurance policy will just dump into the trust that you've already set up. But testamentary trusts are what a lot of people do, and that's perfectly fine. But then you can have terms within that. Use the funds for education up until the point of, maybe age 25. And then after that, then it's to be distributed, at certain intervals, maybe at 25, a certain percentage, 30, a certain percentage, 35, maybe distribute everything at that time. And so there are a whole host of options that are available for how distributions are made. But that's one thing I think is really important is having child. And maybe you could speak a little bit to what a guardianship of the estate entails.
Yeah, and I think that's a great point in terms of thinking about a will-based testamentary trust versus creating a revocable trust during your life, and the peace of mind and ease of administration that comes with the way to the top of the landing and be at that place, or you can get all the way to the top of the stairs, and there's lots of options in between, and sometimes the cost becomes a factor as to how far up the staircase you want to go. But that's the idea. If that testamentary trust is in place and there's question as to where the funds go, those funds need to be held the guardianship for the benefit of the child, or we need to get the trust set up. So we need a testamentary trust, and the account needs to be set up, and all the individuals. And so there's sort of those waiting periods, if you will, of time as to where those assets are and how they go. So that's one of the ease of administration. And as if you were the personal representative or the trustee at the time, so that when the time comes, it handles itself almost automatically.
Absolutely, absolutely. And one of the other articles was, can I motivate my heirs after I'm gone? And that kind of unfortunately die too early. There are some provisions that you can put into a trust and say, this is what I want to see happen. You might even put in some recommendations about what people you want the trustee to work with, like what financial advisor. Some of those may or may not be enforceable, but they kind of help to honor the intent of after you pass away.
Yeah, and I explain that oftentimes with the idea of what we're trying to replicate is if you were still here and able to manage the funds for the benefit of the child. And that trustee essentially steps into your shoes and tries to take that which you would have done and accomplish it until your children reach how the article references you want to encourage your beneficiaries to do X, Y, or Z, because there is too much control can get you in trouble making a trust, but really setting out the parameters and helping that trustee know how to navigate and encourage and potentially even influence how the beneficiaries are handling the funds that left for your kids if that tragic event happens where you're unable to be there for them during your life. And so that's I like the way that's phrased, because I think that's a good reminder that, hey, we can't always lock it in terms of legal certainty, but we can set out what we would like to see happen and provide that trustee with some guidance.
Right, right.
Short and sweet is the way to go, right? So we're here right in the heart of Hamilton County up in Noblesville, Indiana. Easiest way to find us is just search up noblesvilleattorney.com. How about yourself, Thomas?
Yep. And my name's Thomas Vick. I'm the attorney at Vick Law PC in Greenwood, Indiana. We're an estate planning, estate administration, and elder law firm. And best way to get in touch with us. And always subscribe to the YouTube channel.
Yeah, I was
that.
gonna say, let's not forget a couple episodes ago we had a guest on, and that was a great time to chat with a realtor who helps us on occasion work through some of the estate challenges there. So we're always happy to share that information as well. So go check it out.
Absolutely. All right, we'll talk to you later, Seth.
Take care.